Welcome, everyone. Today, let's start our discussion about law of torts. You must have heard about this law of torts, but you must have not seen any particular act, just like Indian Penal Code or Bharatiya Nyaya Sanhita. You must not have seen it. So it's a bit enigmatic, but at the same time, it's very interesting area of law which you must understand because not only it will help you to crack 5 to 7 questions in your legal aptitude area, but it is also very helpful later on when you are going to practice as an advocate. You will be able to understand because the basic ingredients of law of torts are basic to every other law, I will say. Let's understand what is law of torts. Let's understand the nature of torts. A tort is a legal wrong. So understand what is the first thing is it is a legal wrong, you can say, something which is recognized by law as wrong. So something which is not recognized by law is not a legal wrong. It, for example, if you are talking to your friend or you have promised to your friend that today you will be treating him or her with a coffee and you later on refuse, he or she plans the whole day and in the evening you say, call up and say, look, today it is not possible. I was just joking in the morning. So though it is morally not correct, it is very absurd behavior, but at the same time it's not legally wrong. So you cannot sue that person in a court of law. And apart from this very distinction which I have discussed, we'll again discuss in the law of contract as to whether it is binding or not. Just understand a tort is a legal wrong. Second, it is a branch of civil law, distinguished from criminal law or public law. So there are two broader classification. We can broadly divide all kinds of laws and reliefs which we get in a court of law or from a court of law into two broad categories, that is civil law and criminal law. So in civil law, what happens? The outcome, the result of the whole litigation and the process is in the form of decree, in a form of order to pay money to you or putting you back in the original position, something like that, restraining somebody from doing something. While in case of a criminal law, it's more like punishment, sentence, and fine. So the second thing, a third thing is the person who commits a tortious act is called tortfeasor. So in crime, in criminal law, you must have heard about accused or accused person. Here it is called tortfeasor. The victim of a tortious act is the plaintiff in a tort case. So plaintiff is general term which is used in any civil case for the person who approaches a court of law with a plaint, with a pleading that something wrong has happened with me. India's tort law traces its historical origin to the writ system and the common law decisions of the English court. So, largely speaking, we have inherited much of the concepts of the law of torts from the English judgments. So, and later on, which have been developed and reframed and even made better by the Indian courts, particularly the Supreme Court of India. The source of modern tort law in India can be found both in judicial decisions and in statutes. So later on, when because of the judicial pronouncements, the law was also codified in the form of certain enactments. So we have two kinds of sources. One is judicial decisions, and second is the statute. So nature of a tort. Negligence is an example of common law tort in India. I'm just leaving you, I'm not discussing what is negligence because this is a very important concept. We might be having an entire single class for that. Example of common law tort in the Consumer Protection Act 2019, the Motor Vehicle Act 1988, the Workmen Compensation Act 1923, the Public Liability Insurance Act 1922 are examples of statutory torts. Now coming to nature of again, let's understand something more about law of torts. The word tort derives from the Latin word torquere, tortum, and tortus that conveys a meaning of twisted. The word over here is twisted, something which is not a straight, something which is twisted. and thereby linguistically connote a sense of wrong or deviation from what is right. So something which is twisted, which is not right, is, you can call it as a tortuous act. Examples could be trespass to land, conversion, false imprisonment, fraud, assault. These are some of the examples. Now let's understand the definition of the term tort. So first definition is by Pollock, an act which causes harm to a determinate person. So it has to be some person who has faced some any kind of harm, whether intentionally or not. So another very important factor is whether intentionally or not. You will generally, you must have studied, or you must be knowing the fact that in criminal law, in order to implicate, in order to fasten the criminal liability on anyone, it has to be, the act has to be intentionally done. What we call, an act has to be accompanied by mens rea, that is the guilty mind. When there is no guilty mind, there is no crime as such. So here the concept of intentionality or the mens rea is not there. Again, it should not be a breach of, not being a breach of a duty arising out of a personal relation or contract. So in a contract, what happens? Contract is between definite determinate parties. So it could be you, me, so it, or more people over there, but these are determinate and arising out of some agreement between both the parties, and which is either contrary to law. So very important is, it has to be something what we call illegal, or the which the law does not accept as right, or an omission of a specific legal duty, or and there is a specific legal duty which is cast upon you and which you fail to follow, observe. For example, there is a duty when you drive on the road, drive carefully to take care of other fellow persons who are walking on the road or who are driving on the road. If you omit, if you fail to take care and cause an accident, you may be, apart from the damages, criminal liability, you can also be tried for that. A person, the plaintiff, may also file a case again for damages to restitute that person and to compensate for the financial loss and other losses which he has suffered, or a violation of an absolute right. This was Pollak's. Now, second definition, which is very interesting, and I like it more than the first one, is by Ratan Lal and Dheeraj Lal. Civil wrong. So it has to be a civil wrong. It cannot be a criminal wrong, independent of a contract. So it's the rights and duties are not coming out of a contract. It's not a violation of a term of a contract, for which the appropriate remedy is an action for unliquidated damages. So, what is this unliquidated damages? Is a quantum of amount which is considered sufficient to restore or to compensate in a way the person who has suffered the loss, or who is at the receiving end at the hands of tortfeasor. So, what is unliquidated damages? Unliquidated damages is an amount which is not determined by the parties or anyone before the incidents happens. So it's something which the court comes to a conclusion that this much amount has to be paid to the plaintiff in order to mitigate his damages and restore him to the previous situation. Now let's see the difference between law of torts and criminal law. The basis: tort law, criminal law. Crime committed against a tort law is, it deals with something which is committed against a private party between two people, one a tortfeasor and another is the plaintiff. Criminal law is committed, it deals with anything which is committed against public at large. Understand, if, even though if the victim is always an individual, but in the eyes of law, it is always, the crime is always against the society, because society has interest in the well-being of each and every person. Rule and law and order has to be maintained, and if somebody violates those rules and laws, it's an offense against, it's a affront against the society. So the police and government machinery comes into picture and take care of the the accused person. Now, intention, motive, as we saw, we know in criminal, any kind of criminal proceedings, intention is very important, necessary element. If it is not there, generally that offense does not become a criminal offense. But in law of torts, it is not necessarily a very important element. It may be there, it may not be there. You cannot say ki I had no intention and accident happened and I will not pay for the take care and hospitalization of the victim. You cannot say that there was no intention as such. Standard of proof in criminal law, it is beyond reasonable doubt. And in case of tort law, it's more like preponderance of probabilities. Example of a tort law, negligence, which we'll discuss. We will devote a much longer class for that. And example of a criminal action, which is covered by a criminal law, is murder. Then nature of relationship. Tort law involves non-consensual relationships, harm caused by one party to another. So it may not be, it is not necessary that the relationship is of a consensual nature. For example, if you are driving on the road, it is not required that you have to have a relationship, a consensual relationship with every other person who is moving on the road, that he will not harm you and you will not bump your car into that person. So in contract law, sorry, it was tort law and contract law. In contract law, consensual agreement between the parties with mutual obligations. Now, duties, basis is here duties. In tort law, imposed by law to protect individuals and the public. In the contract law, arises from mutual consent and agreement between the parties. Types of liability, typically fault-based, arising from intentional wrongdoing. So, and in contract can be strict or fault-based depending on the terms of agreement. These terms, just bear with me for some time. We'll be discussing all these fault-based and intentional wrongdoing. These things will again come. Remedies, monetary damages to compensate the victim for losses, and specific performance in contract. What are the kind of relief you are going to get for violation of a contract? It is specific performance, rescission, or damages to restore the non-breaching party's position. Aims, what are the aims? What is the purpose we need to have laws in a society? So the first one would be corrective justice. Second would be distributive justice. Third would be economic efficiency. Fourth would be avoidance of future cost. Fifth would be fairness and equality. Now, let's understand the concepts of tortious liability. So, elements of a tort that creates liability. What should be present in a case of tort where we can fasten the liability on the other party, tortfeasor? There three, largely speaking, there are three. One, something wrong, tort, twisted, something which is not acceptable legally or otherwise, and that wrong thing causes harm to the person who is complaining. So you did committed a mistake, you did something wrong which is not legally or socially acceptable. That wrong caused some harm, any kind of harm to the person. Say he lost some property or he suffered some injury, and there is an appropriate relationship between the injurer's wrong and the harm to the victim. So there has to be a relation. You should be responsible for that injury which has befallen, the victim has suffered. So the relation is very important. Unless and until, see, even if there is a wrong committed by you, the harm is happening to the victim, but you are not responsible, activity has not led to that particular harm, then there will be no liability unless and until the victim proves that it was your activity only which has caused that harm to him. For example, A hits and badly injures B with her car while driving negligently. Now, see here. The wrong here is A's driving negligently. Understood? The harm is the serious injury to B. The appropriate relationship between the injurer's wrong and the harm to the victim is borne out by the fact that it was A's negligent driving that caused or resulted in injury to B now is tortiously liable to compensate, to restore whatever damages has happened to B. Now, we have come across the concept of fault liability and strict liability. What is fault liability? The plaintiff, in cases of fault liability, when you as a plaintiff have to fasten liability over a tortfeasor, you will have to establish fault by showing that I was wronged by the defendant. Here is the tortfeasor, and that in doing so, the defendant acted wrongfully, that is, without justification or excuse. So, just take an example. If you are driving on the road and you're driving negligently and you hit somebody, you would be taken to task. It will be criminal as well as tortious liability. But at the same time, the vehicle is an ambulance and the ambulance driver is rushing very fast to save the life of that person. So here, that it's not done something wrongfully. He was not driving wrongfully, though there could be consequences, but not the way which in your case it would be. In a strict liability case, the person does not have to establish the fault of the defendant. Though a judgment of a strict liability does not necessarily mean that the defendant has acted innocently or justifiably. So, will again, illustration will clarify it. Fault liability, just say A punches B in the face and badly injures her, is liable for her fault in committing the tort of battery. For intentional tort of battery to be established, it is necessary that the defendant has the intent to cause a harm or offensive touching of the plaintiff, and the defendant does cause a harm or offensive touching of the plaintiff. You will have to prove all these things. In case of a strict liability, let's see. A's dangerous dog somehow breaks its leash and bites her neighbor, B. Despite A taking the dog owner taking the necessary precaution of buying the strongest available leash and constructing a high wall around her house and therefore not acting negligently. A can always say ki, I had the best leash, I have the high walls. Still, if the dog was dangerous, you must have heard about many incidences happening, read about many incidences happening in societies around you, in localities around you, where a very specific pit bull or that kind of breed of a dog is kept, which is considered very dangerous. And despite the fact the owner has taken all the precautions, say someday the pit bull unleashes itself or runs away from the house and bites somebody, that person would be strictly liable. He cannot say, "Ki I had taken all the precaution, I have kept high, boundary, best leash in the world. I was using still my dog broke it." That cannot be a defense over. Here, A is strictly liable for B to B for the injury B suffers. Then there is another concept of vicarious liability, which is there in the law of torts. Usually, what happens, you are held responsible only for the actions or inactions or omissions which you have done, you were expected to do, and which you failed to do. But vicarious liability is a very interesting concept. It transfers the liability from one person to the other. Let's understand how. A person can be held liable for conduct of another person. The liability that a supervisor party, such as an employer, bears for the actionable conduct of a subordinate or associate, such as an employee, based on the relationship between the two parties. Now, how it is traveling to the main party, vicarious, how it is there. Say, for example, I have employed a driver. He's on my payroll. He drives my car only and nobody else's car. Now, instead of driving my car myself, I have given this task to my driver. So, in the eyes of law, actually, I'm the only driver. I'm driving myself. Now, during that, he's taking me to, say, Connaught Place. And on the way, he bumps the car with somebody and somebody gets injured. Now, for the criminal liability, maybe he is going to be punished. He will be charged with rash and negligent driving. But as far as paying compensation is concerned, I will be held up because in the eyes of law, The relation was there between him and me. I was the employer, he was the employee, he was my subordinate or associate, and there was a relationship with of employer and employee between us. So who has got the deeper pocket, the driver, me as the employer? So the law will hold the person who has employed, instead of doing himself, has given money and asked somebody else to do, and that person has got the deeper pockets, and the court law will catch hold of that person. Now you understand that if this change the scenario, you have hired an Ola or an Uber, and you are driving, your driver is taking you to CP, and now he hits somebody. Now, will you be responsible there? No, because he was not your employer. There is a term called contract for and contract of. So that we'll discuss in the contract law. So he's not your employee and you are not the employer. There is no subordinate superior relationship over there. So for even for damages, you won't be charged, you won't be proceeded against in the court of law. Now, this is based on the doctrine of respondeat superior, which roughly translate let the master superior answer or pay, better to say. So A's servant negligently injures visitor C while cleaning A's house. A is vicariously liable for the tortious act of her servant B. Understood? Okay.